there is a rejoinder affidavit which has been filed, which makes new averments in paragraphs 42 onwards up to para 49 and 90.
Mr. Sibal, is last.
And we would like to put in a response to that because these are new averments which are made, etc. This will require
it was served 2 weeks back. If they want to delay it, they can delay.
You took enough time, sir.
Better ground.
There is also a large additional documents that were filed.
That's correct, but that
needs to be responded.
But 2 weeks back, more than 2 weeks back. Let's have at least some decent ground to delay the matter.
Almost 4 weeks.
No, I'm sorry, almost 4 weeks back. 19th of February, I have the date.
Oh, 20.
New facts are
This is the first. Last week.
at the stage of the Supreme Court.
You start.
But this is just only.
It will not conclude today.
We
will get.
Yes, well, let us start.
We will need time for the purposes of response.
We'll allow you time. Let him start. We'll allow you time.
Yes, let me just give the background.
My lords, how do we
That's
start?
not
It's a shocking fact, my lord. The Honorable Chief Minister barges into an ongoing investigation
That is a different
by the
matter.
central agency.
Look,
And after 4 weeks, they are seeking time to file something.
Against the Enforcement Directorate involving senior advocates, media professionals.
You see, there is serious objection.
Everyone who is
Serious objection to the maintainability also.
Yes,
yes,
my
there
lords.
is. So
yes, my lord, I must satisfy your lordship.
It's being violated.
maybe request the court because the state would like to have the pleadings complete first. Otherwise, it's not a very satisfactory state of affairs.
Pleadings are complete, my lord. I
Complete.
So, Manoj, we would like to file. Our request is that we will require some time to file a response to the rejoinder because the rejoinder, in very lengthy paragraphs, has made assertions which travel beyond the scope of the petition. So it's not a rejoinder in that conventional sense. It's further facts. Now I'm not listening. So we would need time to put in a response.
This is 4 weeks time was given.
No,
yes, but I can give the date of supply, date of service.
This was filed 10
My
days
lord
ago.
may see the rejoinder.
It was given on 19th February.
Factual averments have been made in it, my lord.
19th February. I have the record of the Supreme Court.
No factual averments at the level of the Supreme Court.
It is not about the government.
Whichever is the level, in the 32, it has to be just
Applies
this level.
to 10 days back.
That's a very fundamental thing.
Respond to it. We need to
My lord, we are saying
But
we will
you
respond
could
to
not take instruction for 1 month.
Firstly, my lords, how does the Enforcement Directorate, which has 4 cases where your lordships have granted relief for advocates...
You proceed with the hearings. We'll hear.
So please...
Proceed with the hearing. Mr. Ramji, it is your
My lord may allow us to file the rejoinder, not because there are additional facts.
You proceed with the hearing.
Yes, my lord.
Yeah, no, I would like to, in that case, place my preliminary objection on maintainability first.
Yes.
Lord, can I, only one thing, my lord.
Yes, so
Logically, my lord, only a minute, Mr.
Yes, of course.
Lord, it is my petition. I'll have to first satisfy your lordship why we have come here under 32, for which I'll have to give some basic facts. And thereafter, I'll satisfy your lordships. If your lordships are not satisfied about the maintainability, then, my lord, the question of their raising a preliminary objection will come. Let me satisfy. I'll not, my lord,
Preliminary
have to deal with, my lord, the objection of maintainability. Because I have the
preliminary objection which we want to, because I repeat that appropriate manner to proceed with the case would be after pleadings are complete. If your lordship wants to proceed on some sort of a demurrer on the basis of denials, then we want to place on record, we want to place our submissions with regard to the non-maintainability of this.
So that we decide not only on maintainability, on merits also.
Yes. No, merits, I'm saying that if, as far as the...
No, you cannot choose. How we will decide?
No, if your lord...
You want to file rejoinder and you don't want that...
I want to file
on merits.
I want to file...
Suppose we decide that this is maintainable.
Yes, then my request...
We will hear the matter in one go.
No, that's exactly my point.
Yes, then we complete it.
Yes, exactly. That is my point. That the appropriate manner of hearing a case such as this is in one go. If your lordship is taking it up in one go, then since there are...
You are going in piecemeal.
No, I opened by saying...
Instead of filing a counter on merits also,
I filed a counter on merits. After my counter on merits was filed, there is a rejoinder affidavit which travels far beyond the petition. It's an extensive rejoinder. I am entitled to
Does not have any new facts or its response.
That's not correct, but para 42 onwards is new facts.
But if your lordship ignores the rejoinder, then there is no problem. But if the rejoinder is going to be looked into,
Why should we ignore anything which is on record?
but then please give us time to reply.
Mr. Diwan,
Yes.
you cannot dictate what
Not
we should
dictate, I can
consider and
request.
what we should
I
ignore.
can only request.
What is on record,
Sorry?
what is on record, we'll consider it.
No, but what is on record includes a rejoinder affidavit which travels beyond the scope of the petition. So it's on your normally this is
Telling you,
yes, I'm sorry.
we allow you time, let him finish.
But we have to raise
Benji.
the objection was that this petition itself is not maintainable.
Then you proceed.
That we are proceeding.
Yes, proceed.
Yes, but then that's when your lordships observe absolutely. So we're right to proceed. That is when your lordship observed that there would not be a piecemeal hearing. Which is why what we are suggesting to the court is that if I am putting forth my request over here on preliminary objection, that ought to be heard, considered, decided by the
Hearing, you proceed with
No,
your
but
preliminary
on the merits part. Then on the merits part, because your lordships also observed, and rightly so, that look, it may not be appropriate to have a piecemeal hearing. On the merits, I am a little
You are going hot and
handicapped at this stage. I'm handicapped at this stage because I do not have the advantage of a response.
They had 4 months, my lord. They could have come with some decent reason for delaying the matter, my lord. This is not the
I think
reason.
not, that's a little harsh by the solicitor. Not you give additional facts, we are asking to respond to them, that's all.
10th and 17th, just I'm saying it to your lordship, keeping in mind, nothing else, your lordship, right? 3rd, 10th and 17th, I'm instructed. A little bit side to time. Not once, not twice, not thrice. That should be kept in perspective.
No, but that,
What did you say?
you see, it is not that since they had taken time, you will also take time necessarily.
I'm not saying that.
Yes, it is not a battle for adjournment going on between.
No, we have never sought
In a matter of sensitivity, a matter of
Every matter is sensitive. Every matter is
But
sensitive.
anyway, some matter we feel are more sensitive than others. It requires a detailed
It
response.
may be sensitive for you.
It
For
is
us,
sensitive.
For us, it is definitely unusual. But the way in which the Honorable Chief Minister has barged into and have
Sorry,
snatched
this is not becoming a speech, Lord. Let's
evidence
just,
of a crime is an unusual thing.
that's not fair, no. This is.
False.
She has, my lord, admitted. I'll show that.
Enforcement Directorate has
Why
multiple.
don't you proceed with the hearing?
Lordships
No, I have no difficulty, my lord.
Proceed, please.
Yes.
But we are raising a preliminary objection first.
That is again, same thing.
Again, means what? This is what we have been saying from the very beginning.
So then you begin.
So we are beginning.
When I am requesting you to begin, you don't know. There are some additional material to be brought in.
We never said we will
Okay,
not
so
begin.
may I just broadly indicate on
Yes,
behalf
please.
of the state the 3 broad grounds on which we are going
Yes.
to make submissions. The first ground on which we are going to make submissions is that insofar as the Enforcement Directorate is concerned, it does not, which is the primary and the first petitioner, it is not a corporate entity. It has no corporate existence. It is not a body corporate.
You are,
and
Mr.
most
Diwan, you are
importantly,
appealing
it does not have a right to sue. So this is my
Mr.
first.
Diwan, you are appealing for?
I'm appearing for
Not
the
only
state of
one
West
factor
Bengal.
before Mr.
in
Diwan
which
starts
petition-
on merits.
writ
We have
petition-
keep one factor in mind. State of West Bengal has also filed, my lord, and I will give the number. Writ petition under 32 as State of West Bengal. State of Kerala filed writ petition as State of Kerala under 32.
You
The-
mention it.
And
the
this
state-
governor's, my lord,
You mention it when your turn comes.
I will.
When
I
you
will.
reply.
So Meloy, may I just broadly indicate the 3 heads of submission and then I will develop each
So
point.
you are for State of Bengal.
I'm for the state of West
In which
Bengal,
matter?
which is
In both the
response
matters?
one in, no,
Both
but
the
I mean writ petition criminal 16 of 2026, I believe.
Yes.
16 of
Yes,
2026. yeah.
16.
Right?
Yes,
Yes.
yes.
Now, now the 3 broad heads are, number 1, as far as the Directorate of Enforcement is concerned, it is not a juristic personality. It is not a juristic entity. If it is not a juristic entity, it cannot maintain a petition under Article 32. This will be the first broad submission. The second is that in any case, having regard to Part 3 of the Constitution, because this is a petition under Article 32, there would have to be a breach or a violation of fundamental rights. And absent any violation of fundamental rights ex facie, because according to us, Enforcement Directorate's fundamental rights cannot be breached. So if the enforcement directorate's fundamental rights cannot be breached, then in our respectful submission, an Article 32 petition is not maintainable. That's the second. And the third broad head of submissions is going to be that this issue is one which relates to a very important aspect of interpretation of the Constitution of India as to whether an enforcement directorate can at all maintain a petition, and because it has to do with part of our basic structure. We will place before you the articles of the Constitution which have a design for the purposes of resolving disputes between a central government and a state government. That has a special, it's part of the architecture of the Constitution. And when you have specific provisions and specific channels for redress, those have to be followed. And on our understanding of the law, other types of redress or other forms of petitions are stand excluded. Now, in this context, I would just mention over here at this stage, because this will take you to Article 145 of the Constitution. So may I just request you to please take that up so that I flag the point, and thereafter your lordships can, we will get into the further details. The lordships have Article 145 of the Constitution.
Yes.
I'm just flagging it at this stage.
Rule of court.
Yeah. 145(1) rules of the court, etc. Subject to the provisions of any law made by Parliament, the Supreme Court may, from time to time, with the approval of the President, make rules for regulating generally the practice and procedure of this court, including, and then you have various sub-articles which are there. With your permission, I'm skipping those. 2. Subject to the provisions of Clause 3, rules made under this article may fix the minimum number of judges who are to sit for any purpose, and may also provide for the powers of a single judge and division courts. So this is subject to Clause 3. Now, Clause 3 is really what is pertinent and important over here. The minimum number of judges who are to sit for the purposes of deciding any case involving a substantial question of law as to the interpretation of the Constitution, or for the purpose of hearing any reference under Article 143 shall be 5, provided that where the court hearing the appeal under any of the provisions of this chapter other than Article 132 consists of less than 5 judges, and in the course of the hearing of the appeal the court is satisfied that the appeal involves a substantial question of law as to the interpretation of the Constitution, the determination of which is necessary for the disposal of the appeal, such court shall refer the question or opinion of the court constituted as required by this clause for the purpose of deciding any case involving such a question, and shall on receipt of the opinion dispose of the appeal in conformity with such opinion. So I'll place the entire article. No judgment shall be delivered by the Supreme Court save in open court, and no report shall be made under Article 143 save in accordance with the opinion also delivered in open court. Sub-Article 5, no judgment and no such opinion shall be delivered by the court save with the concurrence of a majority of judges present at the hearing of the case. But nothing in this clause shall be deemed to prevent a judge who does not concur from delivering a dissenting judgment or opinion. So let me just state the point, and then your lordship in the fullness may consider as to whether, but I think it's important for us to flag this issue, because then I don't want to be told that you should have mentioned this at the outset. This question, you see, when we open and when we explain the case, and your lordship in your wide experience already knows, there are a large number of departments, both as far as the central government is concerned and in our states are concerned. Huge number of departments. Now, these departments are there under various forms, rules of business, etc., to carry out and conduct business. The question which arises is, can a department, which is not a body corporate, because in many situations, for example, Parliament sets up, say, something like the Securities Exchange Board of India. When we look at that statute, you will find that it has an express provision which says that an entity such as this has a corporate personality, and it can both sue as well as be sued. When we look at the Enforcement Directorate, it is nothing beyond just a department of government. And that the central government had discretion to establish, we'll place those provisions. Now, when you have a department, it doesn't have any to sue by itself. Now, this becomes very, very important having regard to the larger federal structure and the interpretation of the Constitution. Because your Lordship knows that there is, for example, Article 131. Because what I'm going to develop later on is this, that when you have a department, say, of the central government, equally you could have a department of the state government. That department of the state government, let me start with department of the state government, is nothing but the state. So what you essentially have is a situation where this is the central government which is suing. And it is the central government is suing and asking for relief in respect of Part 3 of the Constitution of India, which are fundamental rights. Now, this itself is a very interesting and an issue which the court will have to look at as to whether you can have the central government complaining that, look, as far as I am concerned, I am the state and I am finding that the state has to, on our broad reading and understanding of the law, is the one which has to guarantee fundamental rights and non-violation of fundamental rights broadly to the citizen. But your lordships have correctly said that it is to persons. So persons may be citizens, may not be all of them citizens. Even if you're a foreigner, there may be certain fundamental rights which you are entitled to. But nevertheless, it has to be some form of personhood which this particular entity as a department doesn't have. Now, when you look at the whole situation across the country, what you will find is that there are several such departments. And therefore, the real issue, why am I starting by mentioning 145.3 is that this is something which, on our understanding, the Constitution itself says that when issues of this kind of importance arise, there ought to be a minimum of 5 judges who decide the case. So this is why I thought I should just flag this, because this is surely an issue which really needs to be referred to, even on the question of maintainability.
मम्मी पापा आ गए पापा
The Constitution mandates that issues like this, which involve the interpretation of the Constitution, can the union government complain of a Part 3 violation? Can the union government come over here and say that there is that a 32 petition at my instance is maintainable? If this happens, broadly, what a court of appropriate bench strength will have to consider is that if we allow this, then the situation may not arise, where you have a surfeit of 32 petitions which are being used by one department against another department across states. It could happen in some situations between 2 states. It could happen in some situations between the state and the center, or as here you have as between the center and the state. So this issue, I would respectfully, I'm just stating it, then we take you to the case law, etc. as necessary. But I thought I should mention this at the outset, because this is really to be appropriately decided by a panel of 5 learned judges, is my respectful submission. Now, my lords, let me just indicate to you first as to who the first petitioner is, which is the history of the Enforcement Directorate. So I'll just give you some background, and then I'll request the court master to hand the Foreign Exchange Management Act. Now, the Directorate of Enforcement, your lordship may just know, was first formed by an executive fiat on the 1st of May 1956. And it was an enforcement unit of the Department of Economic Affairs of the Union government for handling exchange control violations under the then Foreign Exchange Regulation Act of 1947. So that's one thing which your lordship, just historically, that is the background. Then your lordship may note that at that particular time, so initially it was an enforcement unit. Then the enforcement unit, in or about 1957, was renamed as an enforcement directorate. And in or about 1960, the administrative control was moved from the Department of Economic Affairs to the Department of Revenue. So it's really a department, as you will see, within a department, to the Department of Revenue. Then the Foreign Exchange Regulation Act of 1947 was repealed by the Foreign Exchange Regulation Act of 1973. And on our understanding, for a brief period between 73 and 1977, there was a renaming of the Enforcement Directorate, and it came under the administrative jurisdiction of the Department of Personnel and Administrative Reforms. So it still remains a department. Now we come to Foreign Exchange Management Act, and here I'll just request your Lordship to pick up section 36 of the Act first, please.
Yes.
Yes.
Your Lordships have FEMA?
Yes.
May I invite attention to section 36?
Yes.
Now, your Lordship has it?
Yes.
Now, please see, this is a chapter which is chapter 6. Your Lordship has that? And then it says Directorate of Enforcement. So I'll be placing this before you. Directorate of Enforcement, section 36, subsection 1. The central government shall establish a directorate of enforcement with a director and such other officers or class of officers as it thinks fit, who shall be called officers of enforcement for the purposes of this Act. So there's a mandate to the central government under this provision to establish a directorate of enforcement. Without prejudice to the provisions of subsection 1, the central government may authorize the Director of Enforcement or an additional Director of Enforcement or a Special Director of Enforcement or a Deputy Director of Enforcement to appoint officers of the enforcement below the rank of Assistant Director of Enforcement. And subsection 3, subject to such conditions and limitations as the central government may impose, an officer of the enforcement may exercise the powers and discharge the duties conferred or imposed on him under this Act. Now, please see section 37, power of search and seizure. The Director of Enforcement and other officers of enforcement, not below the rank of Assistant Director, shall take up for investigation a contravention referred to in section 13. Without prejudice to the provisions of subsection 1, the central government may also, by notification, authorize any officer or class of officers in the central government, state government or reserve bank not below the rank of Under Secretary of the Government of India to investigate any contravention referred to in section 13. The officers referred to in subsection 1 shall exercise the like powers which are conferred on income tax authorities under the Income Tax Act 1961 and shall exercise such powers subject to such limitations and laid down under that Act. 37A, special provisions related to assets held outside India in contravention of section 4. Upon receipt of any information or advice, if authorized officer prescribed by the central government has reason to believe that any foreign exchange, foreign security, any immovable property situated outside India is suspected to have been held in contravention of section 4, he may, after recording the reasons in writing, by an order, seize value equivalent situated within India of such foreign exchange, foreign security, or immovable property, provided that no such seizure shall be made in a case where the aggregate value of such foreign exchange, foreign security, or any immovable property situated outside India is less the value as may be prescribed. The order of seizure, along with the relevant material, shall be placed before the competent authority appointed by the central government, who shall be an officer not below the rank of the Joint Secretary of the Government of India by an authorized officer within a period of 30 days from the date of such seizure. The competent authority shall dispose of the petition within a period of 80 days from the date of seizure by either confirming or by setting aside the order after giving an opportunity of being heard to the representative of the Directorate of Enforcement and the aggrieved person. And then there's an explanation with which, with your permission, I'm skipping. Then subsection 4. The order of the competent authority confirming seizure of equivalent assets shall continue till the disposal of the adjudication proceedings. And thereafter, the adjudication authority shall pass appropriate directions in the adjudication order with regards to the further action as regards the seizure as made under subsection 1. Then there's a proviso, subsection 5. Any person aggrieved by orders passed by the competent authority may prefer an appeal to the appellate tribunal, and nothing contained in section 15 shall apply to this section. Then empowering 38, empowering other officers. The central government may, by order, and subject to such conditions and limitations as it thinks fit to impose, authorize any officer of customs or any central excise officer or any police officer of any other officer of the central government or a state government to exercise such of the powers and discharge such of the duties of the Directorate of Enforcement or any other officer of enforcement under this Act as may be stated in the order. And subsection 2, the officers referred to in subsection 1 shall exercise the like powers which shall be conferred by the income tax authorities under the Income Tax Act, subject to such conditions and limitations as the central government may impose. Then we come into another chapter, which are the chapter 7 and the miscellaneous provisions. So the reason why I placed the whole of chapter 6 is that, as your lordships will see, first and foremost, under section 36(1), there is a parliamentary or a legislature's directive to the central government to establish a directorate of enforcement. Now, it may do so, it may not do so, so the language is mandatory. In our case, of course, there is a directorate of enforcement. Now, the first thing which is completely missing, so what is it, is the question I ask myself. What is this directorate? According to us, it's an organizational limb or a department of the central government and nothing else. And, sorry.
Yes.
Yeah. So what you have here is, this is really a directorate. So for organizational purposes, for identifying as to who or what can do what items, you have officers which are there under this particular directorate. But it is no, first point is over here, there is nothing under statute, because you also should see, if you are creating a body corporate, it would have, on our understanding of the law, to be done by Parliament. It is Parliament alone which can create this. It can't be done by delegated legislation, or it can't be done by the by the central government, which is a delegate of the legislature. So here, the entire scope of this particular chapter is authority to the central government or power to the central government to establish a directorate. What it doesn't do is more important for our purposes, for the purposes of the present point which we are canvassing. It doesn't confer a right to sue. So this is my first respectful submission, that a right to sue has to be expressly conferred on a directorate. One. Number two, again, something which is absent, it does not create a body corporate. Because someone may be able to argue, the usual design of the statutes is that it creates a body corporate, and its body corporate will have a right to sue and be sued. I am here on the right to sue. So as far as right to sue, so body corporate is also very, very important. The reason why it is not a body, there are two aspects to it. Right to sue, my submission is, has to be expressly conferred, and it has not been done. If the right to sue has not been done, it cannot, in our respectful submission, maintain an Article 32 petition, because it doesn't have a right to sue. Now, there's a second facet to it. Apart from it not being maintainable in the sense of right to sue, the fundamental right, which is essential for Article 32 to be invoked, has to be, according to us, by a person. It may be by a natural person, it may be by a legal corporate entity. But if you have a situation where you are neither a juridical person nor a natural person, again, you do not have a right to sue. Now, I might just mention for completeness that as far as the Enforcement Directorate is concerned, yes, that's all right. Yeah. You may just also note, my lords, but because just for completeness, that there is the Prevention of Money Laundering Act 2002. And here there is Chapter 8, which is with respect to authorities.
PMLA.
Chapter 8, beginning with sections 48 onwards. So just for completeness, I'm sorry. These responsibilities of authorities, while the book is being handed over, you may just note that I'm instructed is exercised by the Enforcement Director. So you must just know that the PMLA is but again, under the Prevention of Money Laundering Act 2002 as well, there is no juristic personality which is conferred. So there may be responsibilities, designation of power, authority to be exercised, but there is no juristic personality conferred, and there is no right to sue conferred. Now I come to another point, which is to say, the book may be handed over, your Lordship may just have a look at that.
Yes. Chapter 8 you will.
Sorry?
Chapter 8 you referred.
Yes, you may just note that. We are really looking at the absence of provisions rather than the positive element.
If there is absence of provision, we did not look into the.
Sorry?
You can only say there is no provision.
No, I'm just pointing out this is the provisions for authorities. The provisions for, because I have indicated to the court that it is the Enforcement Directorate, although department is constituted under FEMA, which your Lordship has seen. They have been given additional responsibilities under the Prevention Money Laundering Act. So the point I'm making here is that even under this statute, which confers additional responsibilities when you are and powers and duties, there is no notion of a juristic entity under this provision, and equally there is no notion of a right to sue. So these two are absent. So your Lordship is quite right in the sense I can't show anything because it's absent. Ensure to me from this. Yes. Now, my lord, sorry. Now, there is some assistance to be gained from a decision of this court reported at 2003, Volume 3, SEC 472. And the title of that case, thank you, is Chief Conservator of Forests versus Collector.
2003, Volume
3, SEC 472. Your Lordships have it?
Yes.
Now, may I just, before I come to the relevant portions, in the sense of this, may I just give you, read some of the introductory paragraphs first. Please just have a look at page 476 of the report. Justice Kadri said, these two appeals are from a common judgment of the division bench of the High Court of Andhra Pradesh in writ petition so-and-so and appeal suit 2291 of 1986. The appeals arise in the same facts, and one set of parties is common. The matter of litigation is an extent of so-and-so acres in such and such district in the erstwhile Nizam's estate of Hyderabad. After accession to the Nizam's state of Hyderabad, with the Union of India, the Andhra Pradesh abolition of Jagirs regulation, so and so, hereinafter referred to as the regulations, came into force. Under the regulations, all Jagirs, including Prol, Jagir, stood abolished from the date of their administration stood vested in the state. Raja S.V. Jagannath Rao was the last Jagirdar. Respondents 3 and 4 are the legal representatives. It is the case of the Patedars that when the state took over the Jagir, the forest department of the state took under its control the forest land at measuring so many acres. However, the land comprised survey number 11 of Asadpur village measuring 1523 and survey number 118, such and such village as measuring 9,000 acres remain for the Raja as his patta land. Soon thereafter, a notification under section 29 of the Andhra Pradesh Telangana Area Forest Act 1935 was issued on 4th of December 1950. The notification enumerated 14 villages comprising an extent of 93,000 acres of Kolhapur Taluk, which is named as the Kolhapur Range. It appears that the notification under section 30 of the Forest Act was also issued, but the notification is not on record. In the year 1953, a resurvey of the erstwhile Jagir was conducted. The land in question, namely survey number old, was assigned survey number 11 and survey number 41 old was assigned survey number 168. However, the finalization of the survey was done in 1962. The Patedars filed an application under section 87 of the Andhra Pradesh Telangana Areas Land Revenue Act.
All these facts are not required. You come straight.
You're right. So then just have a look at paragraph, just have a look. Your Lordship will see para 12, but just give me a moment of this.
It needs to be noted.
Yes, it needs to be. Yes, Your Lordship, sir, para 12?
Yes.
Yes, may I take you to para 12? It needs to be noted here that a legal entity, a natural person or an artificial person can sue or be sued in his or its own name in a court of law or a tribunal. It is not merely a procedural formality, but is essentially a matter of substance and considerable significance. That is why there are special provisions in the Constitution and the Code of Civil Procedure as to how the central government or the government of a state may sue or be sued. So also there are special provisions with regard to other jurisdiction persons specifying as to how they can sue or be sued. In giving a description of a party, it will be useful to remember the distinction between misdescription or misnomer of a party and misjoinder or non-joinder of a party suing or being sued. In the case of the misdescription of a party, the court may at any stage of the suit proceeding permit correction of the cause title so that the party before the court is correctly described. However, a misdescription of a party will not be fatal to the maintainability of the suit or proceedings. Though Rule 9 of Order 1...
Stop making embarrassing writing mistakes. Quillbot for Chrome instantly eliminates grammar errors, so your writing...
It's important to notice that the proviso thereto clarifies that nothing in that rule shall apply to non-joinder of a necessary party. Therefore, care must be taken to ensure that the necessary party is before the court, be it the plaintiff or the defendant. Otherwise, the suit or proceedings will have to fail. Rule 10 of Order 1 CPC provides remedy when a suit is filed in the name of the wrong plaintiff and empowers the courts to strike out any party improperly joined or impleaded as a necessary party at the stage or at any stage of the proceeding. Then the question that needs to be addressed is whether the chief conservator of forests as the appellant petitioner in the writ petition appeal is a mere misdescription for the state of Andhra Pradesh, or whether it is a case of non-joinder of the state of Andhra Pradesh, a necessary party. In a list dealing with the property of the state, there can be no dispute that the state is a necessary party and should be impleaded as provided in Article 300 of the Constitution and Section 79 of the CPC in the name of the state Union of India, as the case may be, lest the suit will be bagged for non-joinder of necessary party. Every post in the hierarchy of the posts of the government set up from the lowest to the highest is not recognized as a juristic person, nor can the state be treated as represented when a suit or proceeding is in the name of such offices or posts of officers holding such posts Therefore, in the absence of the state in the array of parties, the cause will be defeated for non-joinder of a necessary party to the list in any court or tribunal. We make it clear that this principle does not apply in a case where an official of the government acts as a statutory authority and sues or pursues further proceedings in its name, because in that event, it will not be a suit or proceeding for and on behalf of the State Union of India, but by a statutory authority as such. Under the scheme of the Constitution, Article 131 confers original jurisdiction of the Supreme Court in regard to a dispute between two states of the Union of India, or being one or more states and the Union of India. It is not contemplated by the framers of the Constitution or the CPC that two departments of a state or the Union of India will fight a litigation in a court of law. It is neither appropriate nor permissible for two departments of a state or the Union of India to fight a litigation in a court of law. Indeed, such a course cannot but be detrimental to the public interest, as it also entails avoidable wastage of public money and time. Various departments of the government are its limbs, and therefore they must act in coordination, not in confrontation. Filing of a writ petition by one department against the other by invoking the extraordinary jurisdiction of the High Court is not only against the This is the most important part in para 14. Please.
Para 16.
Yeah, I'll come to 16 in a moment. But
Para 16, I have already read.
Para 14, have your lordship seen that filing?
14 also, I have underlined also filing of a writ petition by one department.
By one department against the other by invoking.
Para 16 also I have marked.
Yes.
Where the
Now,
court
says,
so, the fact is that state of Andhra Pradesh was not a petitioner, therefore writ petition was not maintainable.
Yes.
It is over.
So may I just
to the next judgment.
Yeah. May I just place that paragraph 16? Sorry.
She's assisting. But don't look like that. No, it's not a case for laughing.
Sorry.
Don't look as if you were bewildered. If at all you are bewildered, maybe by this side or this side, not. I have utter dislike for this gesturing by the lawyers when the court is putting question. Ma'am, please find.
Yeah. So, Manoj, may I just place para 16? Just for completeness on my part, I'm obliged that your lordship has already zeroed in on the relevant portion. Now, reverting to the facts of the case in hand, we are of the view that after the said statutory order of the Commissioner of Survey, Settlement and Land Records, the matter should have rested there. We have therefore no hesitation in coming to the conclusion that it was not only inappropriate but also illegal for the Chief Conservator of Forests, though he might have done so in all good faith, to have questioned the order of the Commissioner of Survey, Settlement and Land Records before the High Court of Andhra Pradesh in writ petition so-and-so. The Chief Conservator of Forests as a petitioner can neither be treated as the state of Andhra Pradesh, nor can it be a case of misdescription of the state of Andhra Pradesh. The fact is that the state of Andhra Pradesh was not the petitioner. Therefore, the writ petition was not maintainable in law. The High Court, had it deemed fit so to do, would have added the state of Andhra Pradesh as a party. However, it proceeded, in our view erroneously, as if the state of Andhra Pradesh was the petitioner, which, as a matter of fact, was not the case and could not have been treated as such. As the writ petition itself was not maintainable, it follows as a corollary that the appeal by the Chief Conservator of Forests is also not maintainable. We are unable to accept the contention of Mr. Amareshwari that merely because an officer concerned had obtained permission of the government to file an appeal, which is not placed before us, the writ petition and the appeal should be treated as an appeal by the government of Andhra Pradesh. The permission granted to the authority concerned might be a permission to file an appeal, which cannot reasonably be construed as an authorization to file an appeal in his own name, contrary to law. It could only be a permission to file an appeal in the name of the state of Andhra Pradesh in accordance with the provisions of the Constitution and the CPC. We may also record that in spite of the Patidars taking objections to that effect at the earliest, no steps were taken to substitute or implead the state of Andhra Pradesh in the writ petition, in the High Court, or in appeal in this. So, Manoj, and then now we shall deal with civil appeals, so and so, so and so, so and so. So, Manoj, I would respectfully submit that the Chief Conservator of Forests versus and others versus the collector and others is authority for 2 or 3 propositions which we are canvassing. The first of those is, Now, Manoj, with your permission, may I just request the court to just pick up for a moment the Constitution? This one.
Yes.
I have it. I'm sorry. Now, if your lordship, since they were referred to in the course of this judgment, just please take up for a moment 2 articles. Please see the Constitution. Because this is, when I go into that 145(3) question, these are the articles which will have to be construed, and according to us, authoritatively by a bench of appropriate strength. So may I invite attention to Article 300, please. Article 300. Your lordships have?
Yes.
Suits and proceedings. And at a certain level, with your permission, I'm going in reverse. I'm starting with 300, then I'm taking you to 131, and then I'm taking you to Part 3. Now, your lordships have suits and proceedings. 300. The government of India may sue or be sued by the name of the Union of India, and the government of a state may sue or be sued by the name of the state, and may, subject to the provisions which may be made by Parliament, by Act of Parliament, or of the legislature of such state enacted by virtue of powers conferred by this Constitution, sue or be sued in relation to their respective affairs in the like case as the Dominion of India and the corresponding provinces or the corresponding Indian states might have sued or be sued if this Constitution had not been enacted. If at the commencement of this Constitution, A, any legal proceeding pending to which the Dominion of India is a party and the Union of India shall be deemed to be substituted, any legal proceedings are pending before a province, etc., the corresponding state shall be deemed to be substituted for the province of the Indian state. This is a very, very important provision, which, of course, our judgment in Conservator of Forests looks at. Then, you see, I'm just pausing here for a moment. Why does this have to do with federalism, etc.? Let us see 131 for a moment.
This point was decided in that Tamil Nadu governor's issue. When the issue was decided by 2 judges bench, this point was agitated.
Which is, I'll just
that Tamil Nadu versus governor issue versus President of India.
Which issue on locus?
No. This 143 issue. Whether it was decided in that matter?
No. Not the issue. Only about the that was not the issue.
No, it was never issued. Even in a contest between the state and central, or the governor or the state legislature and the President of India, this issue was not decided. Yes, proceed. Just as a matter of fact, I wanted to know.
And it was an Article 32 petition which was entertained at the behest of the state.
So,
No, that this will creep in. Therefore, I am asking this so that
no, I am.
You are alive. What is it?
No, we'll check that up. I'm not very familiar with that judgment, but I'm just indicating to you here. I have now placed Article 300. After having placed Article 300, which your lordships have seen, as to how the state or the central government is to be sued. The government of India may sue or be sued in the name of the Union of India. It can't sue or be sued in the name of the Enforcement Directorate. I'm sorry. I mean, that's an implied prohibition over here, which is rather elementary. But But now I take you to Article 131, which is very, very important because the Constitution has provided a scheme when you want to proceed against, say, another constitutional part of our federation, which is the original jurisdiction of the Supreme Court. Please see that, Article 131.
Yes.
Your Lordship, may I place 131? Original jurisdiction of the Supreme Court. Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute, A, between the Government of India and one or more states, or B, between the Government of India and the state or states on the side and one or more states on the other, or C, between two or more states, if and insofar as a dispute involves a question whether of law or fact on which the existence or extent of a legal right depends, provided that the said jurisdiction shall not extend to a dispute arising out of any treaty, agreement, covenant, engagement, sanad, or other similar instrument, which, having been entered into or executed before the commencement of this Constitution, continues in operation after such commencement of such, or which provides such jurisdiction shall not extend to such a dispute. And then your Lordships will just have a look at a moment. Your Lord, just give me a moment. Now, sorry, may I just make my submission now on a reading of 131 and Article 300? Now, I'll take you also to those rules, but just on the constitutional provisions at this stage. It is our understanding of the law that in the original jurisdiction of the court is in respect of this solving or not solving, but determining disputes between federation, central government and states, one or more states on the other hand, state and state, and states or states on one hand and the central government on the other. Now, this Article 131 jurisdiction, when read with Article 300, prescribes the exact manner in which the entity will sue. And this is central, actually, to the whole concept of a federal form of governance. And why is it so? When you have a suit and an original suit which is instituted, it is to be expected, a huge number of checks and balances. There are systems under whichever the rules of business are, which govern, given the department which seeks to raise it, through which the matter progresses internally within the government. So take a state government wants to file a suit under Article 131, say against the central government. Then there are a huge number of ramifications and authorities and factors which will weigh into the consideration as to whether a suit should be filed at all. Well, and if so, whether it should be filed, on what issues it should be filed. This is the safeguard because the framers of the Constitution and the Constitution as it stands realize that this is a very delicate issue. Because after all, you are having two units or the central, two or more units under the federal structure, which are contesting. So you have 131 and you have 300. If this is the converse situation, if some department of government is allowed to just file and institute a proceeding over here, it goes without any of the checks and balances which would visit are Article 131. You will just have some department which says that let us sue, let us file a 32 petition, let us file a 226 petition. And this completely undermines respectful submission, the federal structure, which is part of the basic structure of the Constitution. Yes. Now, just for now, while you are considering this, there will be another article of the Constitution also on this aspect, which I am just mentioning to you so that for completeness. So you have Article 262, which I must mention because that's part of it's a single constitutional scheme. So please just have a look at it. Just basic for completeness. 262 under the subheading Disputes Relating to Waters. Adjudication of disputes relating to waters of interstate rivers or river valleys. Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution or control of waters of or in interstate river or river valley. Notwithstanding anything in this Constitution, Parliament may by law provide that neither the Supreme Court nor any other court shall exercise jurisdiction in respect of any such dispute or complaint as is referred to in Clause 1. So this becomes a very important carve out because we now have an Interstate Disputes Act. This becomes a carve out of 131 because your lordships have said notwithstanding anything in the Constitution. This particular article has been interpreted by this court to mean that in relation to these type of matters, state water disputes, original jurisdiction would lie with the tribunal constituted under the Interstate Water Disputes Act. But as far as Article 136 is concerned and judicial review are concerned, those being inherent part of the basic structure as well, your lordships have retained to yourselves Article 136 jurisdiction in the case of an interstate water dispute, but not the original dispute. An original action has to be subject to this carve out if it's a water dispute in terms of the parliamentary statute. Otherwise, it has to be under Article 131. Now, please just take up the Supreme Court rules. Part 3.
Yes.
Now, in Part 3, your Lordship will have Order 25.
Yes.
Now, here I'm not going to read the whole of it, but I'm just placing it because this is in respect of original suits.
131.
Yes. So you have parties to suits, two or more plaintiffs may join in one suit in whom any right to relief in respect of or arising out of the same act or transactions or series of act or transactions is alleged to exist. So it could be one or more states, it could be the central government and one or more states, it can be a situation where it is just in the singular, just one state against others. It could be just the central government against one or more states. So those are the kinds of situations which you have. So initially there's parties, then two or more defendants under Rule 2. The court may at any stage of the proceeding, either with or without an application of
The new Full of Life mat, new Double Wear, a mat made for more, just like you, only from Estee Lauder.
Joint to be struck out, etc. And then, there are further steps we'll have seen in Part 3 itself. Further rules with regard to plaints, issue of service of summons, written statement, set off, and counterclaim. And then it goes on for these type of original suits and hearing of suits all the way up to Order 37. Then you have a separate chapter. Please see that. Part B. Petitions under Article 32 of the Constitution.
What you are referring to?
No, I am referring to this to say that there is a specific... Sorry?
Safeguard.
Yes.
Checks and safeguards are there.
Yes, so this is the manner. If the union, I am saying that...
Article 32 petition is allowed in this way, there will be no checks and safeguards.
That's what I am obliged. That is certainly one of our points. But what we are pointing out is that there is a constitutional scheme for an original suit, and that constitutional scheme is expanded upon by procedural provisions under the Supreme Court rules for a suit and a plaint, in contradistinction with Article 32, which is Part B under the same Supreme Court rules, beginning with Order 38. Please see that. Order 38 deals with petitions under Article 32 of the Constitution.
Yes.
This is a completely different type of procedure. This is not a procedure. This is a procedure available to the citizen or to a legal person.
Yes.
Your Lordship has petitions, Part B.
Yes.
Petitions under Article 32 of the Constitution of India. And then it has Article 38, applications for enforcement of fundamental rights relatable to Article 32 of the Constitution. And then, of course, the powers which your Lordships can exercise in terms of the types of writs. And then there is a separate heading for public interest litigations as well. And then it goes into C, which is applications for transfer of cases. That's a separate thing. We're not concerned with that. Order 39 onwards. Transfer of criminal proceedings, etc. Then D, with Order 42, is references under Article 143. Please have a look at that. So there's a structure, there's a form, there's a manner in which proceedings are required to be instituted if you are under 32. And there I am obliged to that observation which your Lordship made. A 32 petition would not go ordinarily. Just say there are so many when a state decides to go against the union. I'm giving you an illustration. There will be so many considerations, my lords, which are thought through. It's not just some department, some officer goes across, says, all right, you take this vakalatnama, go over there, sign it and make. Because these type of petitions, if permitted, that's the respectful submission, can jeopardize the constitutional structure. So whether there are to be checks and balances, are there any further checks and balances required? Can it just be done by any officer over here of some department? I don't believe so. And therefore, we are pointing this out that not only do you have it as far as the overarching constitutional frame is concerned, but it is translated also in the subordinate rule-making power of the Supreme Court, where you have separate types and categories. So you have a suit, you have an Article 32 petition, then you have transfer petitions, which I have mentioned. You just see it, D is references, presidential reference under 143. That is Order 42. Then, as far as the president and vice president's elections are concerned, election petitions under Order 46. So I would respectfully submit, and then of course you have, in terms of other procedures, there's a whole separate part, Manoj, for review, Part 4, and also a section insofar as security petitions are concerned. So this is now the constitutional scheme. Now may I just take your notice to a few statutes. So for example, thank you. So I'm just giving you an illustration, then I'll give you some further. Just have a look that when Parliament seeks to confer the right to sue please just take up the SEBI Act. I'm giving you an illustration. I'm not giving you all, but
SEBI Act.
Yes, SEBI Act 1992. Illustratively, we can furnish a list.
Yes.
May I request you to go to section 3, please?
Yes.
Your Lordship has it? Establishment and incorporation of board, section 3 of the SEBI Act.
Yes, yes.
So I'm giving this as an illustration and then I'll just move on. With effect from such date as the central government may by notification appoint, there shall be established for the purposes of this Act a board by the name of the Securities and Exchange Board of India. The board shall be a corporate by the name of having perpetual succession and a common seal, with power subject to the provisions of this Act to acquire, hold, dispose of property both movable and immovable, and to contract and shall by the said name sue or be sued. Have you marked that? Your Lordship may just be that.
Yes.
So please see 2, 3 things. So when Parliament wants to confer a right to sue or be sued, it appears to do 2 things. First, it makes you a body corporate. And second, it expressly confers the right to sue or be sued. So SEBI, for example, would be able to institute a proceeding. That is something which is significantly absent in the case of the Director of Enforcement, which I have shown your Lordships. Enforcement Directorate is just a department or directorate which is established. The central government shall establish it. No body corporate, no suing. Now, I'll just request the court to just make a note. Instead of taking you to those provisions, I will just mention the provisions which your Lordships may note, which are in pari materia to section 3.
SEBI is a regulatory body.
Sorry? Yes. Yeah, there are many situations, my lord.
ED is not a regulatory body.
Regulatory, it's an enforcement.
The difference between the
Yeah.
the character of two bodies.
There are a lot of, your Lordship is right, but I will give you a list. There may be certain regulatory authorities, but now, since your Lordship is raising this point, I don't think so, though you may have another view. But I don't think the National Highway Authority of India is a regulatory body. I mean, I don't think so. But the National Highway Authority of India under section 3(2), please see the Act, NHAI Act of 1988 if necessary. And section 3, subsection 2 is in pari materia to what I have given you. But I think your Lordship is correct to put this question to us, that you may have certain situations where you have regulatory authorities as well. But a regulatory, so your Lordship is right. But the point is, when Parliament, whether regulatory, the point I am seeking to make is that whether you may have, for example, let me just give you an instance. You may have certain planning authorities. You may have authorities for the purposes of promotion of a particular industrial development in a state. That body or that board which is constituted in a state for industrial development, for example, is not regulatory. It is a promotional body. It seeks to promote industries in a particular state. It's not regulatory. So you have different types. I think your Lordship is correct to put this point to us, that you may have different types of species within this larger framework. But NHAI, your Lordship will find under 3 subsection 2 is in pari materia. Just keep on your rights. Yeah. Your Lordship, thank you. Your Lordships have NHAI 3(2). The authority shall be a body corporate by the name aforesaid having perpetual succession and a common seal with power subject to the provisions of this.
1 minute.
Sorry?
National Highways Act नहीं National Highways Authority Act.
NHAI 88.
National Highway Act, not authority.
No, I see.
National Highways Authority Act.
Yeah. I'm sorry.
They have given National Highways Act.
I see. I'm sure it's available.
Yes.
I find on a reading of it,
Continue.
it's identical.
Yes.
I'll just read it, but it appears to us to be identical. The authority, so it's the board, SEBI. The language, SEBI is the board. Over here, it is the authority. Shall be a body corporate by the name aforesaid, having perpetual succession and a common seal, with power subject to the provisions of this Act to acquire, hold, and dispose of property, both movable and immovable, and to contract, and shall by the same name sue and be sued. So this then becomes a very important. So I'm just giving you that this is a common device which is used by Parliament for the purposes when it is.
In any act, a prosecuting or investigating authority or agency has been made body corporate.
We'll check that up.
You have to check.
Yeah, we'll check that up and we'll get back to you. But I might just mention, since your lordship is mentioning this to me, can I give you a list?
No, because
in answer to the question.
Difference between.
No, so I'm answering. So your lordship's question to me is that is there any that we are aware of a power to sue conferred in this type of an investigation authority or something else? So let me answer the question straight off. Please take number one, Central Bureau of Investigation.
Yes.
No power to sue.
But yet CBI sues.
Still? Yet?
It sues sometimes.
No, it doesn't. It doesn't. 32, it doesn't sue 32. It doesn't file an original suit as far as I know. Maybe it does. But now in any case, we are raising the question over here. Which
they sue and we entertain but never decide that question.
But, well, I don't know about that. That may be. Yeah. But I don't, at least I'm not aware of a 32. But since your question is to me, as your lordship's question is very pertinent, it's very direct. Has a body corporate status been conferred on investigating agencies? That's the question, with the right to sue. So can I just answer that first? So that's out of the way. What is being handed over? The Highway Act. Is it the Highway Act or the Highway Authority Act?
No, it is there in the same book they are.
Oh, I see. Okay.
3-2. Yes. Authority. Yes. Yes, what next?
Yes, so Manoj, may I answer your question? So, as far as CBI is concerned, no power to sue. The relevant statute is the DSPE Act 1946. As far as we have been able to research, the Narcotics Control Bureau, which is under Section 4 subsection 3 of the NDPS Act 1985, has no power to sue. Yeah,
if there is a power to sue,
yes,
like NHAI.
No, I'm saying no.
I'm just pointing a question,
yes,
raising a question.
Yes, yes.
If there is a power to sue in a body corporate like SEBI,
I'm planning to give you a list of other.
Just listen to me.
Yes, yes, of course.
Whether in that case Article 32 would be maintainable on behalf of SEBI. Or
so, may I just answer that?
No, this will arise.
It may arise, but that's exactly why we see 145.3 in the right forum. It's a very important question.
Yes.
I think your lordship is looking at it. I am looking at it from, I'm from the state of West Bengal, which is the party at the constituent home for whom I'm advancing a case.
You are giving these examples.
Yeah, but I think the case, your lordship's vision is much wider. Your lordship has to look at it from a much broader perspective.
Yes.
Much broader than just state of West Bengal.
You make it broader always.
Yeah, no, but that's the.
Why it has to be broader?
No, but that's the perspective which a Supreme Court, is by its very constitution and its existence required to do.
You are absolutely.
We are very narrow, we are trying to confine. No. But I think the point which you make is very important. Yes. Namely, that apart from state of West Bengal, some other state and the central government, 131, a further issue may also arise. Because we have so many statutes. Now, your lordship's question is pertinent from two perspectives. One, you have central statutes which create body corporates, but equally you have state statutes which also create body corporates.
Yes, yes.
So you have so many legal entities and body corporates, both regulatory, promotional, having different types of functions which we cannot exhaustively enumerate. Now the question will therefore arise as to whether for all or any of them, they can also maintain a 32 petition. So I will of course come to part 3, but I think your lordship's vision is much broader, and that, if you consider it appropriate, may also consider referring that to a 145(3) question, whether it arises here or not, but certainly it's a perspective which will have to be kept at the back of our minds. So now, my lords, I'm answering on 2 aspects. First, I'll mention just two sets of acts. One is, you may just note the section. I won't take you because the acts are all similar in pari materia. As far as body corporate with right to sue is concerned, you find it under the Competition Act 2002, Section 7(2). You find it under the TRAI Act 1997, Section 3(2). You find it under the Insurance Regulatory and Development Authority Act, Section 3(2). You find it under the Unique Identification Authority of India, the Aadhaar Act, what is abbreviated as the Aadhaar Act, which may not be strictly regulatory in that sense, but they also have been given this power to sue and be sued under Section 11, Subsection 2. You have the Food Safety and Standards Act 2006, under which the Food Safety and Standards Authority has been given corporate status and a right to sue and be sued under Section 4, Subsection 2. National Highway Authority Act, your lordships have noted, 3, Subsection 2. And you have the Pension Fund Regulatory and Development Authority Act, Section 3(2). Now, a similar list can be made for the various state governments, but I think I'm alive to, I appreciate, because I think your lordship's perspective is the correct one, which is to say that these are just a handful of state, of union government central statutes. There will be dozens and dozens of state statutes as well, which confer a body corporate right and a right to sue. Will they? The question then is, sorry. Yes. Yes.
That if being or not being a body corporate is not the test to consider the of maintainability of Article 32 petition, is this argument should detain us for long?
No,
this is a body corporate, this is not a body corporate.
No, so can I just put it 2 ways?
Yes.
I have 2 separate arguments.
Yes.
One is the right to sue or be sued. That's one part. The second limb of the argument is, you are either a juristic entity or a natural person. That's, a body corporate I have been using because the sections say body corporate. But the concept as we understand it is, you have to be a separate juristic entity. That's the second dimension. So if you are not a juristic entity, according to me, you can't sue, period. It's out.
No, but we cannot generalize also that if you are a juristic entity, by being a body corporate under some statute, then you can maintain Article 32.
No, that's a separate argument. That I'll come to when I deal with part 3. You're absolutely right. It is a whole complete different ballgame and a different set of constitutional provisions. I am saying, without going so far to part 3, we are not even reached part 3 yet. We are just on the structure and frame, having regard to the Constitution and having regard to the Supreme Court rules. So we have pointed out original proceedings are different. We have pointed out 32 petition is completely different. So therefore, first and foremost, you have to, in our submission, you ought to be a juristic entity, which you are not. On our construction, you are not. If you are not, then you can't complain about X, you can't sue. 1. Number 2, the parliamentary statute under which governs you, which is essentially FEMA, under which, and then I told you that there are some additional authorities, powers and responsibilities given under PMLA, neither of those confer a right to sue or be sued. So that's a separate argument. There may be some situations where I can't envisage too many, but there may be some situations where you are a juristic entity, but you cannot sue or be sued. There may be some situations like that. There may be an embargo under the statute itself that we can't allow you to proceed and sue or be sued, but you are a corporate entity. And there are 2 concepts here as well, according to us. One is the right to sue, and the other is to be sued. So to be sued is also a separate concept. We are concerned, of course, with the limited aspect of whether you can, in fact, sue. Now, Manoj, I'm on another aspect. Now, I'm just moving to another point, which is also an answer to your Lordship's question. The question was, who, if any, of these authorities like police who can investigate, etc., have been conferred a right to sue under their parent statutes? So my answer is that our limited research has indicated, now I just request your Lordships to note this, the Central Bureau of Investigation has no right to sue under the DSPE Act of 1946.1. I'm staying first with the central government. The Narcotics Control Bureau, which is a bureau under the Ministry of Home Affairs, has no power to sue according to us under Section 4(3).
And it's high up in the air. ये तो out है. Tissues. ये तो 6 है. Party.
Number 3, the Directorate of Revenue Intelligence, which was established under an executive order in 1957, has also no power to sue. The Serious Fraud Investigation Office, SFIO, under the Ministry of Corporate Affairs and established under Section 211 of the Companies Act 2013, has no power to sue. And the IB, which is the Intelligence Bureau, Ministry of Home Affairs, established under executive orders dating back to 1887 and 1920, has also no power to sue. Very important. Why is it important? Because I'll just complete my list of just now, since we are for West Bengal, I should just inform you. The CID, the Criminal Investigation Department of the West Bengal Police, which is under the Police Act, there are executive orders dating back to 1906, no power to sue. This is very, very important, because if this is to be allowed, all these people will be suing one another. I mean, just imagine. West Bengal State Vigilance Commission has no power to sue. Please just note that. We have an anti-corruption branch established under a notification that too has no power to sue. Now, I just step back for a moment and I'm just considering. If each of these authorities, because keep the central government aside for a moment, you have situations where you have people who cross over from one state to the other, for shelter. Jurisdiction in states under a federal structure, obviously territorially limited, etc. Now, I'm trying to visualize a situation where if a power to sue is conferred on all these various departments like the ones which I mentioned, CID, Intelligence Bureau, Serious Frauds Office, Narcotics Control Bureau, etc. If each one is entitled to sue, then apart from 32, I think it's a very small step to thereafter also have 226. And 226 in one state against some jurisdictional officer of another state. And please remember, my lords, if we are to have a situation where these type of investigative officers are going to be given authority to draft a writ petition and file a writ petition, either under 226 or under Article 32, according to us, there is a considerable possibility of danger. Danger not just at the level of burdening the court, but there's a danger to the federal structure. The entire federal structure and the federal machinery will be tested extraordinarily in a manner not envisaged by the Constitution of India. The Constitution of India envisages 131 if you have the union government, which is essentially the enforcement directorate. It has no body, there's no legal, separate independent legal status. There's no, it's not corporate or not juristic personality. None of the rights conferred by this part is guaranteed. And then your lordships, I read that earlier part, etc. So I would respectfully submit that having regard to the scope and ambit of Part 3 of the Constitution, for the Enforcement Directorate to even seek to invoke some article or some breach is completely elementary notions in our respectful submission. And it may not be enough to say that that's a respectful submission, that look, we have evolving concepts, etc., and therefore please evolve the Constitution. There has to be some textual and purposive reason for this. There doesn't seem to be. And there's a very good and compelling reason for not allowing this. that we have suggested to the court, that otherwise you will have all sorts of any directorate, any division, without going through the rigor and discipline of a 131 suit, just filing a petition which will create havoc on our, at least in our understanding. So, my lords, now I just want to mention the point, and then I'm coming to a few decisions. The point is that state versus state is nowhere contemplated under Article 32 of the Constitution. So, your lordship shall just keep that. Now, the Enforcement Directorate did seek to invoke this parens patriae, etc., and it did approach the Bombay High Court under Article 227 of the Constitution. So the Bombay High Court passed a detailed order. I'm going to comment 2 paragraphs of reasoning in that because I think that might persuade the court. I mean, at least in terms of the constitutional gravity of this case. And so I'll place that reasoning, and I might also indicate that our court here then declined to interfere. So let us just see what the reasoning here is. Your lordship sees this is a judgment which is rendered. Sorry, you have it? Yeah, I've just handed it over. So it's a judgment of 21st December 2020. Give it to them. It's titled Directorate of Enforcement versus State of Maharashtra and others. Your lordship has it? Okay. So this is, your lordship may just note it, it's a division, it's a single judge, 21st December 2020. Now please go directly to paragraph 17. So the pages are at the foot of the page, 19. Your lordships have it?
Paragraph?
19. Oh, sorry, my mistake, 17.
Yes.
The petitioner ED, your lordship has that part? I'll just place it.
Yes.
The petitioner ED claims to be an injured, a victim in a representative capacity of the victims. According to the petitioner ED, the ED being a victim of economic offences which are serious in nature, having large repercussions on the economy of the country, would have locus to be heard before the closure report is accepted. According to the petitioner ED, the offence being a crime against society, it is the duty to ensure that the culprits are properly prosecuted. Learned ASG submitted that the petitioner ED would fall in the category of interested person, as the agency, the Enforcement Directorate, is not only entrusted to bring the offenders to book, but is also entrusted with the task of ensuring that money laundering does not take place. He further submitted that the petitioner ED, being intrinsically interested in the outcome of the FIR, is entitled to be heard before the closure report is accepted. Reliance is placed by the learned ASG on observations in certain judgments relied upon, stating that the object and reasons of enacting the PMLA cannot be disputed. However, the judgments relied upon have no bearing on the facts of the case, inasmuch as the said judgments pertain to rejection of bail under PMLA. Having considered the law in this regard, the petitioner ED, by no stretch of imagination, can either be construed to be a victim or an aggrieved, injured, interested person, thus entitling them to be heard before a magistrate decides whether the closure report ought to be accepted or not. The respondent number 1, State of Maharashtra, is an investigating agency in the present case who has filed a closure report in a case instituted by the respondent number 2, Akbar Travels. The petitioner ED is not a supervisory authority over the respondent number 1 state who has investigated the case. Take a hypothetical example, a converse situation. If in a given case, any other investigating agency feels that the Enforcement Directorate has not investigated the case properly, can the said investigating agency intervene in the investigations being carried out by the Enforcement Directorate? Can they be permitted to do so? The obvious answer is no. Each investigating agency is expected to investigate the case before it fairly on the basis of the material gathered by them during the investigation and thereafter submit its report. No investigating agency can claim supervisory jurisdiction over the other in a matter of investigation. In the present case, the magistrate is yet to pass an order on the closure report. It is for the magistrate, after hearing the parties, to consider whether to accept the closure report or not, or to direct further investigation to issue process. The respondent number 2 complainant is contesting the closure report for filing the protest petition. Petitioner ED is an independent investigating agency empowered to investigate under PMLA and FEMA, and in the facts cannot be termed as a victim of aggrieved, injured, interested person having regard to the judicial pronouncements. There's no provision in law which supports the claim of the petitioner ED with respect to its locus to intervene and contest the closure report. Thus, the petitioner cannot be permitted to intervene and contest the closure report filed by the respondent number 1 state. Now, this came up, and that's the short order, I believe, which is also handed over? Yes. On 26 September 2022, having heard so-and-so for the respondent, so-and-so, keeping in view facts, circumstances of the case under which the impugned order came to be passed, we see no reason to interfere. Question of law, if any, raised is kept open. Needless to mention that the petitioner has any other rights and remedies, they may avail the same. So the Directorate of Enforcement itself had come up, and it was felt that this is not an appropriate case for intervention, for interference under Article 136. Now, my lords, the issue on Article 32 and the necessity that there is required to be a breach of violation of fundamental rights, and failing that, no 32 lies, is also the subject of several judgments of your lordships. I'm starting with the Constitution Bench judgment in Ramdas Athavale versus Union of India, 2010, for SCC, page 1. Yeah. Yes, this is the one we have to go through. You already have it. No, second last. Your lordships have that judgment?
Yes.
May I indicate the appropriate paragraph? According to us, there are 46 and 47, which are right towards the end.
46?
Yes, right at the end. Last page.
Yes.
So this is the court speaking through Justice B. Sudarshan Reddy. It is equally well settled that Article 32 of the Constitution guarantees the right to a constitutional remedy and relates only to the enforcement of the right conferred under Part 3 of the Constitution. And unless a question of enforcement of fundamental rights arises, Article 32 does not apply. It is well settled that no petition under Article 32 is maintainable unless it is shown that the petitioner has some fundamental right. Now, may I pause here for a moment? The Enforcement Directorate has no fundamental right. In Northern Cooperation Union of India, this court has made a pertinent observation that when a person complains and claims that there is a violation of law, it does not automatically involve breach of fundamental right, for the enforcement of which alone Article 32 is attractive. We have carefully scanned through the averments and allegations made in the writ petition and found that there is not even a whisper of any infringement of any fundamental right guaranteed by Part 3 of the Constitution. We reiterate the principle that whenever a person complains and claims that there is a violation of any provision of law or constitutional provision, it does not automatically involve a breach of fundamental right, for the enforcement of which alone 32 of the Constitution is attracted. It is not possible to accept that an allegation of breach of law or a constitutional provision is an action in breach of a fundamental right. The writ petitions deserve dismissal. So here, of course, according to us, they fail. The petition fails on a demurrer on both counts. First, you're not a person who has any fundamental rights. And secondly, apart from locus, which is the point which we are canvassing, there's no question of you being the state complaining about some other organ of the state violating your fundamental rights. State versus state is not within Part 3 of the Constitution at all. Now, this has been, of course, followed by the dozens of judgments. So I'll just give your lordship one other, which is 2016, 2 SCC, page 315. So may I just give you the paragraphs first and then place them? Sorry. Oh. Yeah. May I just give you the paragraphs which I'm relying on? Because they are paras 17, 19, 21, and 27. So 17 is at page 321. I'm just on this one issue, the 32 fundamental rights has to be breached. Let me quickly add, the Union of India, if it sues in its name, may in certain situations be entitled to invoke the parens patriae. So it may be. I'm not saying it can be done. I don't believe it can be done under 32. But there may be a suit which parens patriae jurisdiction which they file or an action. Lordship recalls in Bhopal, for example, they invoke that particular doctrine on behalf of the victims, etc., where you can't. So there may be situations. But I don't believe Union or the Union of India can at all file as parens patriae in terms directly under 32. That's my respectful submission. But in any case, even assuming it is the Union of India which has to so file. It can't be a directorate of enforcement. Otherwise, every division and department will say that I'm looking after the interest, parens patriae, and here I am in court, ready and willing to assist the court. I don't believe that's permissible. Now let's see para 17. From a reading of Article 32, it is manifest that under subclause 1.1 of Article 32 guarantees the right to move the Supreme Court for an appropriate writ for the purpose of enforcing the fundamental rights included in Part 3 of the Constitution. The sole object of Article 32 is the enforcement of fundamental rights guaranteed by the Constitution. It follows that no question other than relating to the fundamental rights will be determined in a proceeding under Article 32 of the Constitution. The difference between the Article 32 and 226 of the Constitution is that while an application under Article 32 lies only for the enforcement of fundamental rights, the High Court under Article 226 has a wider power to exercise its jurisdiction not only for the enforcement of fundamental rights, but also for ordinary legal rights. It is equally well settled that the court under Article 32 will not interfere with the administrative order where the constitutionality of a statute or order made thereunder is not challenged on the ground of contravention of fundamental rights. At the same time, if the validity of the provisions of a statute is challenged on the ground other than the contravention of fundamental rights, this court will not entertain the challenge in a proceeding under Article 32 of the Constitution. Northern Corporation versus Union of India. A petition under Article 32 of the Constitution was moved by the transferee licensee holder. The maintainability of the application under 32 of the Constitution was seriously objected by the Union of India. Writing the judgment, the Honorable Sabyasachi Mukherjee, the then Chief Justice, held. However, there is a far more serious objection in entertaining an application under 32 of the Constitution. Article 32 of the Constitution guarantees the right to move the Supreme Court for enforcement of fundamental rights. If there's a breach of a fundamental right, the petitioner can certainly have recourse to 32 of the Constitution, provided other conditions are satisfied. But we must, in all such cases, be circumventive of what is the right claim. In this case, the petitioner, as such, has no fundamental right to clear the goods imported except in due process of law. Now, in the facts of this case, such clearance can only be made on payment of duty enjoined by the Customs Act. In a particular situation where customs duty is payable at the rate prevalent or a particular rate on a particular date or not has to be determined within the four corners of the Customs Act 62. The petitioner has no fundamental right as such to clear any goods imported without payment of duties in accordance with law. There is procedure provided by law for determination of the payment of customs duty. The revenue has proceeded on that basis. The petitioner contends that duty of a particular rate prevalent at a particular date was not payable. The petitioner cannot seek to remove the goods without payment at that rate or without having the matter determined by the procedure envisaged and enjoined by the law for that determination. The petitioner, without seeking to take any relief within the procedure envisaged under the Act, has moved the court for breach of a fundamental right. This is not permissible and should never be entertained. In a matter of this nature, where the liability of a citizen to pay a particular duty depends upon the interpretation of law and determination of facts and the provision of a particular statute for which the elaborate procedure is circumscribed, it cannot conceivably be contended that enforcing those provisions of the Act would breach fundamental rights which entitle a citizen to seek recourse to Article 32 of the Constitution. We are therefore clearly of the opinion that relief under 32 is wholly inappropriate in the facts and circumstances of the present case. And then they go on for the procedure, etc. Now just have a look at paragraph 21 as well, which makes reference to another judgment. In Ram Javaya Kapoor versus State of Punjab, the petitioner was carrying on the business of printing, publishing books in the sale of including textbooks and in schools in the state of Punjab. The state of Punjab decided in furtherance of the policy of nationalization of textbooks for the school students. According to the policy, all the recognized schools had to follow the course approved by the course of studies approved by the government. The petitioners alleged in support of their petition under Article 32 that the Punjab government had, in pursuance of their policy of nationalization of textbooks, issued a series of notifications regarding the printing, publication and sale of these books and thereby ousted them from their business altogether. Dismissing the writ petition, a 5-judge constitution bench headed by the then Chief Justice observed, as in our view, the petitioner have no fundamental right in the present case which can be said to have been infringed by the action of the government, the petition is bound to fail on that ground. This being the position, the other 2 points raised by Mr. Pathak do not require consideration. All the petitioners, as the petitioners have no fundamental right under 19(1)(g) of the Constitution, the question whether the government could establish a monopoly without any legislation under 19(6) of the Constitution is altogether immaterial. And then it goes on to further elaborate. And then, my lords, finally, your lordship may just see para 27. Under Article 32 of the Constitution, this court is not supposed to go into finding of facts recorded by the authorities and to come to a different conclusion. Moreover, having regard to the law settled by the Constitution bench of this court in a number of decisions, in our considered opinion, the right so claimed by the petitioners are not fundamental rights, and hence the same cannot be agitated directly before this court under 32 of the Constitution. Nonetheless, the next decision which I wish to place is a recent judgment in the presidential reference. Now here, what's it? No, I don't do this one. Either. No, this one. No, okay. No, I want to say something. No, just your lordships have your lordships saw the title, right? In assent without assent holding or reservation of bills by the governor and the President of India. Now, my lords, the entire presidential in the first paragraph, as is customary, which is on page 2, opening paragraph sets out, your lordship has that?
Yes.
Opening para 1. So, as is customary, the court sets out the presidential reference in toto. And here, the main question is question 1, which is at the top of page 4. What are the constitutional options before a governor when a bill is presented to him under Article 200 of the Constitution? Your lordship has that? Now, please see, now this is coming from the President of India requesting an opinion from this court. Now, please see question 14, which he framed on page 5. Does the Constitution bar any other jurisdiction of the Supreme Court to resolve disputes between the Union government and the state governments, except by way of a suit under Article 131 of the Constitution? So this was an express question which was framed, which I think comes up in our present case, though it can take different forms. Now, what our court did, which is entirely within the prerogative of our court, is that it can return the reference on certain aspects without answering them. The lordship will find that in paragraph last page, 165.14. Last page. Question 14, your lordship has that?
Yes.
Pertaining to the court's jurisdiction to resolve disputes between the union and state governments outside Article 131 is also found to be irrelevant to the functional nature of the reference and hence returned unanswered. Returned unanswered. But I thought we should point this out because this is really something which the President also sought some assistance of the Supreme Court, but our court felt that in the facts and circumstances it may not be necessary at that stage. Now the question arises under 145.3, which I have placed this morning. Now, just for some guidance on this principle under Article 145.3, I would like to first take your lordships to in Pradeep Chandra Parija, which is 2002 1 SCC page 1, our constitution bench has explained the mechanics. Sorry. Yeah. So your lordship recalls the question is also, our court has also laid down that a bench of 2 learned judges cannot directly elevate the matter unless there's a conflict, etc. of 3. But insofar as 145.3 is concerned, that is exceptional. If a bench of 2 learned judges are satisfied that there is a question on the interpretation of this constitution itself which is involved, then 2 can elevate it, in the sense, request the Chief Justice of India and frame the questions, etc., and request the Chief Justice to proceed. Now, if, your lordship may just see paragraph 2, may I read para 2? Para 2.
Yes.
The question is whether 2 learned judges of this court can disagree with a judgment of 3 learned judges of this court, and whether, for that reason, they can refer the matter before them directly to a bench of 5 judges, your lordship. That was what they were considering.
Yes.
We may point out at the outset that in Bharat Petroleum, a bench of 5 judges considered a somewhat similar question. 2 learned judges in that case doubted the correctness of the scope attributed to a certain provision in an earlier constitution bench judgment, and accordingly referred the matter before them directly to a constitution bench. The constitution bench that then heard the matter took the view that the decision of the constitution bench binds a bench of 2 learned judges, and that judicial discipline obliges them to follow it regardless of their doubts about its correctness. At the most, the bench of 2 learned judges could have ordered the matter to be heard by a bench of 3 learned judges. Learned counsel for the appellants drew our attention to the provisions of Article 145, clauses 2 and 3 of the Constitution of India. Clause 2 empowers the making of rules to fix the minimum number of judges of this court to sit for any purpose. Clause 3 says that the minimum number of judges who are to sit for the purposes of deciding any case involving any substantial question of law as to the interpretation of the Constitution, or for the purpose of hearing any reference under Article 143, shall be 5. Learned counsel drew our attention to Order 7, Rules 1 and 2 of the Supreme Court, Rule 66. Rule 1 says that every cause, appeal, or matter shall be heard by a bench consisting of not less than 2 judges nominated by the Chief Justice. Clause 2 says that wherein the course of a hearing of any cause, appeal, or proceeding, a bench considers that the matter should be dealt with by a larger bench, it shall refer the matter to the Chief Justice, who shall thereupon constitute such a bench for hearing. Learned counsel submitted that the bench of 2 learned judges that made the reference in this case did not overrule the judgment of 3 learned judges in the case of Nityanand Kar, and they should, as they could have, on the basis of an earlier constitution bench judgment, which incidentally is not even mentioned in the referral order, but had chosen to refer it to the Chief Justice who had constituted a constitution bench. In Learned Counsel's submission, the circumstances would arise where it would be permissible for a bench of 2 learned judges directly to make a reference to a constitution bench. For example, when 2 judgments of a constitution bench were in conflict with each other, or a judgment of 3 judge bench was per incuriam. In Learned Counsel's submission, the present was a case which justified reference directly to a constitution bench. The Learned Attorney General submitted that a constitution bench judgment of this court was binding on smaller benches, and a judgment of 3 learned judges was binding on bench of 2 learned judges, a proposition that Learned Counsel for the appellants did not dispute. The Learned Attorney General drew our attention to the judgment of the Constitution Bench in Subcommittee of Judicial Accountability versus Union of India, where it has been said that no coordinate bench of the court can even comment upon, let alone sit in judgment over, the discretion exercised or judgment rendered in a cause in a matter by another coordinate bench. The Learned Attorney General submitted that the appropriate cause for the bench of 2 learned judges to have adopted, if it felt strongly that the judgment in Nityanand was incorrect, was to make a reference to a bench of 3 learned judges. The bench of 3 learned judges, if it also took the same view of Nityanand Kar, could have referred the matter to 5 learned judges. In the present case, the bench of 2 learned judges has in terms doubted... Para 7 is important for us, Manoj. The last line. The only situation where 2 learned bench may refer a matter directly to the Constitution bench is when the provisions of Clause 3 of Article 145 are attractive, which I believe is the case over here. So that is why this. Yes, and then that other one. This is the other one. Now, you may just note the citation of 2005 2 SCC 673, which is also a constitution bench in Central Board of Dawoodi Bora, also a 5-judge bench. And here, Manoj, I'm just inviting attention because they refer to and approve, I mean, they were bound by it, but paragraph 5 is relevant. I'll just read that statement. In Bharat Petroleum Corporation case, the Constitution Bench has ruled the decision of 2 learned judges of this court binds the bench of 2 learned judges. At the most, they could have ordered that the matter be heard by a bench of 3 learned judges. Following this view of law, what has been declared by this court in Pradeep Chandra Parija clinches the issue, which is what I had mentioned, that that's the situation where 2 learned judges can indeed refer it. Have you given me that? Yeah. Now, my lords, I am just going to place before you the 9-judge bench judgment of S.R. Bommai. May I just give you the para numbers, Manoj, because there's a plurality of opinions over here.
Yes, yes.
So can I just state the point? I think it's well settled, but you never know these days. So the federalism is part of the basic structure of the Constitution. And decisions like the present one will reverberate right through our entire federal structure. If you are going to go into one department to raise Article 32 petitions or 226 petitions, who is not a person with no right to sue. So it has huge reverberations which will go right through. So I will, with your permission, give you the paragraph numbers where learned judges have held that in the basic structure, constellation of rights or features which are protected, federalism is one of them. So you can't make India, as I understand it, into a unitary, non-federal, for example, nation. So here, Lords, I'll just give you the paragraphs. So there's paragraphs 96. What is this mean? At 106. This page or? The Lordship will just give me a moment. Yeah. So para 106, Manoj. Manoj, paragraph 106 of the judgment at page 118. The federal principles, social pluralism, and a pluralist democracy, which form the basic structure of our constitution, demand the judicial review of the proclamation, etc. That was Justice Sawant speaking in para 106, speaking for himself, and Justice Kuldeep Singh. Then your lordships may just go directly to paragraph 247, which are the conclusions in Justice K. Ramaswamy's judgment. The state, qua the constitution, is federal in structure and independent in its exercise of legislative and executive power. However, being a creature of the constitution, the state has no right to secede or claim sovereignty. Qua the union, the state is quasi-federal. Both are coordinating institutions and ought to exercise their respective power, adjustment, understanding, accommodation to render socio-economic and
Reading
political...
from 247.
I'm reading, yes. Because that's the first line. Federalism envisaged in the Constitution is a basic feature. Your Lordship has that. So 247. And then your Lordship will just see paragraph 276 in Justice Jeevan Reddy's judgment.
276.
270, paragraph 276.
Yes.
Who supports the majority. The fact that under the scheme of the Constitution, great power is conferred on the center vis-a-vis the states does not mean that the states are mere appendages. Within the sphere allotted to them, states are supreme. The center cannot tamper with powers. More particularly, the courts should not adopt an approach, an interpretation, which has the effect or which tends to have the effect of whittling down the powers reserved to the states. It's a matter of common knowledge that over the last several decades, trends world over towards strengthening the central governments, be it a result of advances in technology, scientific fields, or otherwise. And that even in the USA, the center has become far more powerful, notwithstanding the obvious bias in that constitution in favor of the states. All this power puts the court on guard against the conscious whittling down of the power of the states. Let it be said that the federalism in the Indian constitution is not a matter of administrative convenience, but one of the principles, the outcome of our own historical process and a recognition of ground realities. This aspect has been dealt with elaborately by Sri M.C. Setalwat in the Tagore Law Lectures, Union and State Relations under the Indian Constitution. The nature of Indian federalism, with reference to its historical background, the distribution of legislative powers, financial and administrative relations, powers of taxation, provisions relating to trade, commerce, and industry, have all been dealt with analytically. It is not possible, nor is it necessary for the present purposes to refer to them. It is enough to note that the Constitution has certainly a bias towards the center. It's equally necessary to emphasize that the courts should be careful not to upset the delicately crafted constitutional scheme by a process of interpretation. So I commend this, Manoj, the wisdom of this judgment to your lordships as well, that there's a very delicately crafted scheme over here, and having regard to that, given the remedies, etc., it may not be appropriate for the for entertaining these particular petitions. Now, the Enforcement Directorate, this is not the first time that it made an effort to petition your lordships. It did so in the past as well. And here I wish to just place two writ petition orders. I mean, they're not certainly binding, but it just is probably gives you a hint about what might happened in those cases. So this is one. You have them? Give them. The first is an order of 9th February 2024. It's a very short order where the Directorate of Enforcement had come up in 32 against the state of Chhattisgarh. And on 9th February 2024, in their wisdom, they decided to withdraw the petition. So that's the first order. The Lordship sees on top, writ petition criminal. The second order is more recent. It is 8th of April 2025. This is again writ petition criminal. The title is again Directorate of Enforcement versus State of Chhattisgarh. Learned Additional Solicitor General seeks permission to withdraw the writ petition under 32, and the same is disposed of as withdrawn. Learned Additional Solicitor states that he is relying on an affidavit, so and so, therefore the file of this disposed writ petition shall be kept along with SLP, and gets tagged with an SLP. So at least this is what we were able to show with respect to our research. So Manoj, this is a preliminary point which I believe merits consideration by the Supreme Court. Yes.
In fact, these two orders should be shown to them rather to the court.
Shown to them? No, all I'm saying is it's, I mean,
Precedential value of withdrawal.
it has no precedential value. It has absolutely no precedential value.
Shown to them means if they become wiser and do the same.
Well, no, wisdom is not anybody's. It's not for me to suggest that. But in our respectful submission, there's also, Manoj, I might just mention that I'll just give you the citation. In Keshavananda Bharati as well, there is a observation with regard to federal structure being part of the basic structure. This is in the judgment of Justice Shelath and Grover. I'll give you the citation and the paragraph number. So 73 for SCC 225. We have just that relevant extract is being given. 1973, volume 4 SEC, page 225. So Justice Shelath and Grover were part of the majority. Last line in para 486 on page 408. The Constitution has all the essential elements of federal structure, as was the case in the Government of India Act 1935, the essence of federalism being distribution of power between the Federation of the Union.
486 you are reading?
Yes, last line on page 408, in 486, you're right.
Last line in 408 or 409?
On page 408.
The constitution has all essential elements.
Yes, of a federal structure. And distribution. And then it goes on to elaborate the federal feature, etc., of the constitution. So, Manoj, I would respectfully submit that in our understanding of the law, this is really a very an issue which sort of bristles with dimensions, and a very profound and deep issue which has ramifications, as I have indicated. It's perhaps an appropriate case to be decided authoritatively by a bench of 5 learned judges. I'm very grateful. Thank you.
Sure. After my learned friends, Maharaj, the detailed, exhaustive, and learned presentation, Maharaj, I'll try and add a bit of my wisdom if I have left any, Maharaj. But on his wisdom, Maharaj, we'd rather rely on your wisdom than theirs.
No. It is the collective wisdom of all.
Now, Maharaj, let's briefly, Maharaj, what my submission is going to be. And it's going to be, I'm not going to repeat anything that my learned friends have said. Well, what is PMLA? PMLA is a statute which empowers certain officers who are authorized under the statute to investigate. That's the PMLA. Nothing more than that. So every officer so authorized is empowered statutorily to investigate an offense. This is true, Maharaj, of all investigating agencies which are authorized to investigate under a statute. It is true of the code. It is true of CBI. It is true, Maharaj, under the Drugs Act, NDPS. So there's an authorization by the statute. So fundamentally, there can't be a fundamental right in these officers. No officer has a fundamental right to investigate. Right? I start with that proposition. Now, Maharaj, let's look at the statute so that we know, Maharaj, what the extent of rights are. Kindly have a look, first of all, at the definition. Section 2, clause D, small a.
Section
2, clause D, small a.
Yes.
Authorized person means an authorized person as defined in clause C of section 2 of FEMA, which my learned friend pointed out to us at the beginning. Then kindly come to, before that, 2 small c, assistant director. Means an assistant director appointed under subsection 1 of section 49.
Yes.
Then kindly come to 2 small j. Definition of deputy director. Means a deputy director appointed under subsection 1 of section 49. Then come to the definition of director, 2 small k.
Yes.
Director or additional director or joint director means a director or additional director or joint director, as the case may be, appointed under subsection 1 of section 49. Right, Buzz?
Yes.
Now kindly straight away come to section 40, and I'll come back. The PMLA is not an authority under the Act.
Yes.
PMLA is no locus, as far as this Act is concerned. There shall be the following classes of authorities for the purposes of this Act. What are those? Director, additional director or joint director with reference to 2K, deputy director, right, Mullah, with reference to 2J, assistant director with reference to 2C, and such other classes of officers as may be appointed for the purposes of this Act. So they are investigating officers. An investigating officer has a right under the statute to investigate. He has no fundamental rights. Now, what is he to investigate? Kindly come to 2 small NA.
Yes.
Investigation, I'm sorry. Investigation includes all the proceedings under this Act conducted by the director or an authority authorized by the central government under this Act for what? For the collection of evidence. So that authority authorized, well, you go back to 49, as I indicated to your lordships. So that's the investigation to be done under this Act. Right? Now kindly come to 2 small s. Definition of person. Person includes an individual. And the reason why it is defined is because they want to ascribe the powers of the director, deputy director, assistant director to entities defined in S. You can investigate a person, an individual, an HUF, a company, a firm, and an association of persons or a body of individuals, whether incorporated or not, societies, right? Whether incorporated or not. Then let's kindly come to the definition of 2U, proceeds of crime.
Yes.
Proceeds of crime means any property derived or obtained directly or indirectly by any person. That's the definition of person I just gave to your lordships in 2S. So if a body corporate, an individual, or any of those persons, HUF, derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. Not any offense. Scheduled offense. Or the value of such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. So they are entitled to investigate proceeds of crime in respect of a scheduled offense. And your lordships will see the scheduled offense is set out in the schedule itself. Right? There are any number of offenses that are set up. We won't go into that for the moment. Then property. Property means any property or assets of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and includes deeds and instruments evidencing title to or interest in such property, assets of whatever nature. And then the offense, is defined in 3. Right? So, I just read it. Whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with proceeds of crime. Proceeds of crime must relate to a predicate offense, a scheduled offense. If there's no scheduled offense, there'll be no proceeds of crime, right? Including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property shall be guilty of the offense of money laundering. Then an explanation is added, and the word or is and is changed to or. If you'll see, look at the definition. In the main part, it is claiming it as undated property shall be guilty of offence of money laundering, Millets. And then, Millets, kindly see the explanation. It says, for the removal of doubts, it's hereby clarified that the person shall be guilty of money laundering if any person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activities connected with the proceeds of crime, namely concealment, the same Miller's word as in the main section, possession, acquisition, or use, and projecting. Instead of and projecting, it says or claiming as tainted property. Or projecting instead of and projecting. So they changed the explanation, doesn't matter. We're not concerned with it. We're not concerned with that. Now, let's kindly come to section 16. Now, 60 is the power to issue summons. Or assist you with the power to have a survey, notwithstanding anything contained in any other provision of this act.
60 is attachment.
16.
What, 16?
16.
Yes.
Power of survey. Notwithstanding anything contained in any other provisions of this act, where an authority, and that authority is defined, director, deputy director, assistant director, and all others authorized for us. On the basis of material in his possession has reason to believe, the reason for such belief to be recorded in writing that an offence under 3 has been committed, he may enter the place. So much as the power of survey, that's not a fundamental right, that's a statutory right. Right, because he's entitled to do that. No issue on that. But then there is no, we're ad item on that. We're not questioning the power of the authorized person to come and do what they have to do in terms of the statute. The question is they have no fundamental right. That's the issue, because this is a 32 moved under 32 minutes. Then search and seizure. Again, where the director, section 17, where a director or any other officer not below the rank of deputy director authorized by him for the purposes of this section on the basis of information in his possession has reason to believe, the reason for such belief to be recorded in writing, that any person, that person is 2S, which I read to your lordships, then they can actually search and seize. Again, regulated by law, regulated by the statute, right? MLS, to this extent, it is different from the Code of Criminal Procedure, because the nature of search and seizure under the code is somewhat different. Now, MLS, slightly come to, then they can retain the property, we're not concerned with it. Then, let's kindly come to section, then 48 I have read to your lordships. Then kindly come to section 49. I read 48 to your lordship, now 49. So, the central government may appoint such persons as it thinks fit to be authorities for the purposes of this act. So the power is with the central government to appoint persons under the statute to carry out the purposes of the statute. And to that extent, it's a regulatory statute as well as an investigative statute. Then, section 50. The director shall, for the purposes of section 13, have the same powers that are vested in a civil court under the code while trying a suit in respect to the following matters. Again, power of discovery, enforcement, enforcing the attendance of persons, including officers, of a reporting authority. The reporting authority here are banking authorities. We're not concerned with that. Compelling production of records, receiving evidence or affidavits, issuing commissions for examination. So your lordships will notice that the entire petition contains that this is the officers who went there under the statute and they wanted some documents. They wanted the production of some documents. Those documents were taken away. That's the tenor. But that's nothing to do with the fundamental right. I don't know how the fundamental right comes into the picture. Where none of these authorities which have these powers under the statute have a fundamental right for this. They have only statutory rights. Now, let's kindly see further. Then, Malad, subsection 2. The director, additional director, joint director, deputy director, or assistant director shall have power to summon any person whose attendance he considers necessary, whether to give evidence or to produce any records during the course of an investigation or proceeding under this Act. Now, Malad, your lordships put the question to us, if somebody obstructs such a proceeding, what are the remedies? Well, there are remedies available under the BNS itself. There are remedies available under the law, Malad. The remedy is not a writ petition under 32. Because what are you trying to enforce? Not anybody's fundamental right. These are statutory powers given under the statute, Malad, and it's regulated. Their powers are regulated. Now see further. So give it. All the persons so summoned shall be bound to attend in person or through authorized agents, as such officer may direct, and shall be bound to state the truth upon such subject, any subject respecting which they are examined, or make statements, and produce such documents as may be required. Every proceeding under subsection 2 and 3 shall be deemed to be a judicial proceeding within the meaning of 193 and 228 of the Penal Code, and subject to any rules in this behalf by the central government. Any officer referred to in subsection 2 may impound or retain in his custody for such period as he thinks fit any record produced before him in any proceedings under this Act. Then, let's kindly come to jurisdiction of authorities is 51. The authorities shall exercise all or any of the powers and perform all or any of the functions conferred on or assigned, as the case may be, to such authorities by or under this Act. There is no power outside this Act, Malad. So which is the fundamental right that they are claiming? Forget about, Malad, the larger issue of 131 and the central government and that this doesn't have any corporate personality. Forget that. Under the statute itself, none of these authorized persons have a fundamental right. And if they don't have a fundamental right, certainly the enforcement director doesn't have a fundamental right. The enforcement directorate, Malad, has the central government appointed these officers. Now, see further, Malad. So I was reading, the authority shall exercise all or any of the powers and perform all or any of the functions conferred on or assigned, as the case may be, to such authorities by or under this Act, or the rules framed thereunder, in accordance with such directions as the central government may issue for the exercise of powers and performance of functions by all or any of the authorities. Now, the issuing of the directions or orders referred to in subsection 1, the central government may have regard to any or more of the following: territorial area, classes of persons, classes of cases, and any other criteria specified by the central government. That's also under the Act. Then power of the central government to issue directions. The central government may from time to time issue such directions, instructions, and directions to the authorities as it may deem fit for the proper administration of this Act, and such authorities and all such persons employed in execution of this Act shall observe the follow such orders, instructions, and directions of the central government, provided that no such orders, instructions, or directions shall be issued so as to require any authority to decide a particular case in a particular manner or interfere with the discretion of the adjudicating authority in exercise of its. And then 53, the central government may by a special or general empower an officer not below the rank of director of the central government or the state government to act as an authority under this Act. Even a state government authority, Malad, can be so authorized by the central government to act under this Act. And then certain officers to assist with the officers of custom, that's 54. And Malad, thereafter, you have 63. Punishment for false information or failure to give information. So if somebody fails to give information, there is a punitive section. Any person willfully and maliciously giving false information or so causing an arrest or a search to be made under this Act shall on conviction be liable for imprisonment, which shall be which for a term which may extend to 2 years, or with fine which may extend to 50,000 rupees or both. And if a person legally bound to state the truth of any matter relating to an offence under 3 refuses to answer any question put to him by an authority in the exercise of its powers under this Act, or refuses to sign a statement by him made in the course of any proceeding which an authority is legally required to sign, to whom a summons is issued under 50, either to attend or give evidence or produce books of account or other documents at a certain place and time, omits to attend and produce books of account or documents, he shall pay by way of penalty, and if he doesn't follow it, then a prosecution will be launched against him under subsection 4, 174 is the section. So the scheme of the Act is that it's a regulatory statute with investigative powers, where authorized persons whose powers are, the contours of whose powers are controlled by the statute. It's like saying, election law, nobody has a fundamental right to fight an election. These are all statutory rights. So, the first question that your Lordship...
Fundamental right is to fight outside.
That also we have no fundamental right. We have a fundamental right, to keep peace. Anyway, that's our duty. So, the schedule that your Lordships will see is that page 51, offences. This is, unless there's a predicate offence, this ED doesn't come into the picture at all. What does that mean, First, an FIR is to be filed. Then the ED comes into the picture. Otherwise, ED doesn't come into the picture. Now, there's no FIR in this case, right? They have come under 32. Under what provision of law have they come under 32? Neither the statute allows it, nor the Constitution allows it, nor Part 3 allows it. But their purpose is not that at all. What they are claiming in the petition is, please ask the CBI to investigate this. But the ED can't ask that. ED can't ask the CBI to investigate bullets.
No, it is not the offence under PMLA which the CBI will inquire.
Of course they are inquiring. They went there only for that.
You must consider and keep in mind that everything is in relation to that incident.
I'm coming to that.
But I'm making it clear, we are not asking that CBI should investigate PMLA offence.
Not
PMLA. The offence is committed by the Honorable Chief Minister and others.
Did I say PMLA offence? A scheduled offence.
It is.
You are
not even scheduled offence. Anyway, we will.
Let's just hold on.
None of these.
Unless there is a predicate offence, the ED doesn't come into the picture. The ED does.
It is quite this particular incident of the Chief Minister.
Where is the scheduled offence? Where is the scheduled offence?
It is not about scheduled offence.
Then what
is the offence? These are 4 offences which you have registered against them.
Yes. That's a different.
No, that is the only thing. What they have come.
No. The petition. I'm sorry. Then obviously, your Lordships have not seen the prayers in the petition. Not that at all.
Let us read again together.
Yes. Of course.
It is not for any offence under PMLA which they have come here.
PMLA, not PMLA.
Yes.
Not
and
PMLA.
You are showing the entire PMLA Act and the scheme of the Act.
The scheme of the Act meaning that they have no fundamental right to invest. They have no fundamental right to invest. But let's see the petition. It's better.
Yes. So what we have understood is, on a reading of the petition is that the officers of the ED are claiming fundamental right where their safety while investigating the offence, that is only an incident of investigating an offence. But their main plea is that while investigating the offence under PMLA, they have been threatened.
Correct.
They have been threatened.
Correct.
And they have committed the offence intimidating
allow me. What's the fundamental right there? Assuming they have been threatened. What's their fundamental right?
That they will answer.
I'm sorry. No. I'm asking myself the question. No, what's that fundamental right, Mullah?
No, we will answer at the end, not now.
Let's see the BNS, Mullah. Very simple, Mullah. The answer is here.
Yes.
Kindly see. Kindly see section 221 of
No, let us first read the relief.
We'll see, but since your lordship asked me this question, that look, they are wanting that nobody should interfere, the BNS has the answer.
Yes.
BNS obstructing a public servant in discharge of his public duties, functions. That's the answer.
Now,
It's an offense.
now let us read the prayer.
Now let's see. Page 40.
Page 46.
Let's see the prayer. Let's be clear, Malaj, as to what they are asking.
BNS.
Issue a writ of, I'm sorry, page 46.
Yes, yes.
Issue a writ of mandamus directing the CBI to register FIRs. There it is. Banerjee says nothing. Has nothing to do with CBI. It's here it is. Register directing the CBI to register an FIR. How can ED ask for that? And investigate the entire incident in relation to obstruction of ED's search conducted on 8/1/26. The answer is in BNS. At both the residential premises of one Patik Jain as well as the office of Indian PSC Consulting Private Limited, described in detail above, including the role of the respondent number 2 being the present Chief Minister for whom I am appearing, the Commissioner of Police Calcutta, the Director of General of West Bengal, and all persons acting in concert. So they, Malaj, thwarted the attempts of the ED.
In this prayer, where is the scheme of PMLA coming into?
Because they can't ask, ED can't ask the CBI to investigate. This is to be a separate predicate offense.
But it's not a predicate offense at all, my dear sir. It is not a predicate
If you don't mind, unless there is a predicate offense under the code, now under BNS, ED cannot come into the picture. That is settled law.
As an investigative agency,
ED cannot file a writ petition for their fundamental right. They have no right to file a writ petition to have the CBI lodge an FIR.
Mr. Sibal will continue on Monday.
Yes,
Please,
that's
sir.
fine.
Please, sir.
Yes, that's fine. Yeah. It's miscellaneous, but it's miscellaneous.
Tuesday, you wanted to, because
Tuesday.
Tuesday would be better.
Wednesday, my lords. Then
No, Wednesday would be, you see.
Thursday, whatever suits my lord.
No, Tuesday,
Any last working day became before long holiday.
No. We also want a holiday. You want to work on the last working day. Tuesday is fine. Tuesday.
No, judges.
Tuesday is fine.
It is, though this 23rd,
Tuesday is fine.
25th is Wednesday, but for being the last working day of
Tuesday.
I like Friday.
Tuesday, Lord, Tuesday.
Tuesday, my lord.
Tuesday.
We are at item that 25th is not the correct date. We are at item.
Called Mr. Syam Diwan.
Tuesday, Lord, Tuesday.
Tuesday.
And
Yeah.
just one minute. Mr. Syam Diwan. Kapil Sibal is yet to conclude his arguments. Post the matter on Tuesday as part of it. We'll take it Tuesday.
Tuesday, Lord. Grateful.
Grateful, my lords.
Item 19, whatever date in all other matters, whatever date suits to learned advocates, they may take whatever date.
In one matter, there is an interim relief till today, maybe extended.
Interim relief to until
Item number 19, I will take it on Tuesday, Marad.
Tuesday, it will not happen.
It won't
Don't take unnecessary. Knowing fully, all you see big guns are going. You think it will be
In the dark.
concluded?
In the dark.
And Mr. Banerjee, you know, I'm not commenting anything because
He's a double barrel gun, mother.
double barrel and there is
cannon.
one barrel outside also. You see, if Mr. Banerjee starts about two of us, very difficult.
But item.
I am not so much.
Oh no, it is on the lighter side.
But I am not so much loudly here, but I am really there.
You have to be louder here also.
No.
They are not giving you.
My problem is this, Lord. Everyone misunderstands me. My voice is
No, no, we want to hear you also. We want to hear you also.
No, no, it's a,
Yes.
my great reason, my Lord.
Yes,
Thank you,
yes.
Lord.
Lord, 15, the next item also interim order is limited.
I mean, both not. They are going together. They are going together.
No, why interim order? Now he is controlling state or other matter. There is no problem. Mr. Solicitor.
You see, this is what Mr. Kapil Sibal is right, double barrel. It's a very loaded statement.
Mr. Solicitor.
It's a very loaded statement. That he is controlling it. It is the election commission which is.
I do not know.
Your statement is loaded.
I never control anything. But my Lord, tomorrow, my Lord, it would be reported that Mr. Banerjee considers that Mr. Mehta is going to rule the state.
No,
I am not concerned. I am not concerned. I don't know.
Mr. Banerjee is saying that for a limited time you are controlling. Thereafter they will again.
Solicitor General, be happy with the 1 month and 15 days.
That is what I am saying. What I am
neither happy nor unhappy.
Nobody knows who will rule.
And
Whatever.
one thing, just in a very lighter sense, I am saying. See, my Lord, during last 5 or 7 years, at least 5 or 8 times, I have brought sweets and etc. from my constituency. But never Mr. Solicitor General has invited me for a coffee.
I plead guilty, Lord. I plead guilty.
That's right.
I have been the beneficiary of it.
Ask me whether I am incorrect or not.
No, I concede.
And sometimes I have been misunderstood by others. I mean, what to understand? Why you are bringing sweets for me?
No, you bring sweets to, you see, from your state, we also get sweets.
Yes.
No, Mr. Banerjee always makes it a point to.
I have a grievance because I never get any medal.
You get it in some other form.
In my constituency?
Yes.
Mr. Sibal would agree.
Yes.
My personal, at a personal level, not professional or any other level, I get many things before Mr. Sibal.
That is true.
Even from his residence.
But but Mr.
We can't complain sitting here.
Yeah.
We may complain.
Well, Mr. Solicitor General, another one thing possibly your lordships do not know. In every occasion, whatever it may be, he sent wishes in Bengali and in a very nice write. Yes. He never sends any anything in English.
He loves literature and all that.
Yes. That's
Mushaira, Sairi,
That's right.
poetry, like Mr. Sibal also.
Mr. Sibal, I am working with him since 1990.
He is versatile.
I am working with him since 1990. I argued a matter in Supreme Court 82-83. I used to say to him, you are our, that time, this is 1990, you are our Maradona.
What?
Maradona.
Oh. Diego Maradona.
Anywhere.
Not the other Maradona.
Both, that footballer.
Yes. That hand.
Yes.
And hand of God.
And my sides are two very senior councils that time and famous. One side, I was all the time. Whenever I used to come, either Mr. Simple or Mr. Chip.
And Mr. Diwan is Pele.
Mr. Diwan, I got it always other side.
Now you're saying.
Now we are in the same boat.
That's
anyway.
Sorry.
Okay.
Nice. It's so nice.
I have regular
Which date you want?
First or second, madam.
So,
That's a miscellaneous day, Your Lordship. The Lordship will have to post a
First or
next.
second, madam.